Good morning. Well, this breakfast seminar could hardly be more topical and timely. I mean, look at the headlines last week. Met is going to go London-wide with automatic facial recognition. What is going to be the effect of that? Well, Big Brother Watch said that the decision to go London-wide presents an enormous expansion of the surveillance state and a serious threat to civil liberties in the UK. Well, is it really that dire? Because used in the right way, I think many members of the public would say it is a proportionate and effective tool in making us safer and our communities safer. But perhaps the key to that is used in a proportionate way. One of the primary objections to the use of AFR, which is promulgated by a number of the civil liberties organisations, is that the law is not sufficiently robust to deal with the advances in AFR technology. Well, is that really right? I don't think the courts would agree, because if you look at what was said by Lord Neuberger in the Singularis Holdings case, he said, as new problems arise and as societal values and practices, technological techniques and business practices change, it's inevitable that judges can and should introduce new common law principles or procedures, or make alterations to establish common law principles and procedures. So they clearly think there is enough flexibility in the system that we already have to embrace the new technologies which are coming through at real space now. The first legal challenge to the use of live AFR technology was the case of bridges. It was inevitable, wasn't it, that there was going to be a direct challenge to the use of this technology at a relatively early stage. There are legitimate concerns for the use of the technology and about the possible abuse, most importantly, of that technology. The challenge in the Bridges case arose in the context of a Home Office sponsored trial of the use of AFR, which was conducted by South Wales Police. It's true to say that in the context of Bridges, the trial was very, very carefully controlled. And when you look at the decision that was made in Bridges, you will have to pay close attention to the fact that perhaps the use of the AFR locate in Bridges was not as wide in scope as the media would have had you believe. SWP, South Wales Police, used the AFR technology in different ways, but in the Bridges case it was only AFR locate that was under consideration. What did AFR locate do? Well, it captured thousands of faces, but importantly, if there was no match to the watch list which had been created, those faces were immediately and automatically deleted. And that was a very important factor in the decision of the court. What AFR locate does is it uses a live CCTV feed in conjunction with AFR technology, and there is a watch list of people of interest in order to alert the police in this trial to anyone on the list. And the system will flag them up. Typically, it was used at sporting events, big concerts, music festivals, shopping centres, and these were the sort of uses that were tested when the Bridges case came before the courts. The watch list is most often comprised of those who are wanted on warrant, who have skipped bail, who perhaps are known football hooligans, missing people, vulnerable persons who are being sought. These are the sort of watch lists that can be compiled. But I pause there to say this, that arbitrary use of AFR to pick up anybody and everybody is not going to be supported by the courts. There has to be a specific aim, an identified aim in the use of the technology, and the use of the technology has to be necessary and proportionate to that aim. So what about the challenge in the Bridges case? Well, Mr. Bridges himself was a privacy campaigner who lived in Cardiff. He was present on 2 occasions when AFR locate was used, and there were very different examples. One was in a shopping centre, and one was at a demonstration against the arms trade. And there were basically 4 grounds of challenge in the Bridges case. It was asserted that AFR locate was unlawful because, first of all, it was a breach of the privacy rights under the HRA and Article 8. Secondly, it was a breach of information rights under the DPA. Thirdly, that the police didn't have adequate data protection impact assessments as required by Section 64 of the Act. And lastly, that there was a failure to comply with the public sector equality duty under Section 149 of the Equality Act. So it may be seen from the grounds that are set out there that it was a pretty comprehensive attack on the use of AFR. And many of you in this room will immediately note that although some of the grounds, and in particular the HRA ground, is specific to public authorities, the Data Protection Act challenges are going to apply equally, at least in part, to private companies or individuals who are using AFR for the purposes of their business. And for you who are in the business of AFR in this room, that is going to be a very important factor, because there will be many who say, well, no, this is really a human rights issue, it's a privacy Article 8 issue, we don't have to worry about it. That is a naive view, and it won't be supported. The DPA does impact upon the use of AFR, and so the technology has to address, and I think you'll be told does address, those issues in a very comprehensive way, because the design and use of the technology is obviously an important factor in deciding its lawfulness. So in terms of the result of Bridges, turning firstly to the Article 8 ground, because I use this first because although the findings were in Bridges specific to Article 8, they also overlapped into the DPA as well. So when you're looking at the use of the technology and the proportionality, that is also going to impact upon the DPA grounds, as we'll see. So first of all, the court unhesitatingly decided that the use of AFR did amount to an interference with privacy rights under both the Act and Article 8. Now, if we have a look at that, the fact that the filming was in a public place was not sufficient for South Yorkshire Police to show that AFR did not constitute an interference. Now, to the uninitiated member of the public, that may seem strange because, of course, anybody can film anyone else publicly. But the courts were very clear that the fact you're in a public place, or the fact that you're in, for instance, a privately owned shopping centre, doesn't mean that it cannot be an interference, and indeed concluded that it was. However, the court went on to conclude that that interference was lawful because the existing legislative package was comprehensive and was sufficient. Importantly, the court concluded that there doesn't have to be a specific statutory basis for using AFR. So you don't have to have a piece of legislation which is entitled the use of AFR and all the conditions. What the court concluded was the package that is available at the moment, if properly applied, is sufficient to provide both the transparency and openness in terms of the legislation for the use and the protections that are necessary. And it's a pretty comprehensive package because you've got primary legislation, Human Rights Act, Data Protection Act, Protection from Freedoms Act, you've got the Law Enforcement Directive, you've got secondary legislation in the form of codes, so you've got the codes and guidance of the Secretary of State under the Surveillance Camera Code and the Surveillance Camera Commissioner's AFR guidance, so you can see we're building up quite a body of legislation. And then importantly as well, and this will apply both across the public and private sectors, South Wales Police, in using AFR, had put together policy documents, standard operating procedures and operational advice, all of which were clear and unequivocal as to the way in which the AFR was going to be used in the course of the trial. And this was a really, really important factor, so far as the court was concerned, in showing that this was not an arbitrary use, but a very closely targeted and very clearly articulated use of the technology. Lastly, the court concluded in respect of ground one that the use of AFR locate was both necessary and proportionate in the context of bridges. Now, in reaching that conclusion, what they said was that there had to be a close standard of scrutiny in determining whether the use of AFR in any given circumstances was, in fact, necessary and proportionate. And this test will carry over to the DPA as well in terms of the use of AFR. Because one of the factors is whether a less intrusive measure could have been used without unacceptably compromising the objective, and essentially whether a fair balance had been struck between the rights of the individual and the interests of the community. Now, there are a number of factors if one looks at that. It must be, said the court, deployed in an open and transparent way, so you can't secretly film somebody. Now, this is important because in the context of the South Yorkshire Police case, what they were doing is they were not using it citywide, they were using it in an event-focused or a location-focused way against specifically targeted watch lists. And they were handing out leaflets or putting up signs saying that the AFR locate was being used. And this was a central factor in the decision. It was also being used as for a limited time and on a limited footprint. And again, considered to be important factors. It was clearly targeted and directed only at those who needed to be located for good reason. And the court accepted that the technology had specific benefits. Now, you can see from those factors that there is an expectation that there is going to be a significant degree of control over the use by the user of the system. Hasn't moved. So, turning into the DPA, which for private individuals and companies is going to be of more application, the factors taken into account in respect of the Article 8 issues are applying equally to the DPA, but in a slightly different way. The use of AFR locate was said by the court to amount to sensitive processing of personal information, in that the technology individuates in the individuals from all others. And so it was that factor which made this a sensitive processing under the DPA. There was an adequate policy in place to render the processing in accordance with the law, because of course we all know that there's the Act and there are the various protections within it. It's clearly accessible and usable legal framework. But the lawfulness in Bridges relied on compliance with the first data protection principle, which is that the data must be processed lawfully and fairly. And so the lawfulness and fairness will bring in the same factors as one looked at when we were looking at the Article 8, so the close scrutiny factors. How long are you using it for? What are the aims? Over what area is it being used? How is it being controlled? Grounds 3 and 4, 3 was the Section 34 law enforcement processing, and ground 4, public sector equality duty. Again, the court concluded that these grounds failed and the processing was lawful. The public sector equality duty is an interesting one because it concerned the possibility, and this is something that I'm sure Nick and Dave will be able to deal with later in terms of the quality of the technology. But it concerned the possibility that AFR might produce results which were indirectly discriminatory on grounds of sex or race, because it was thought and it was argued that perhaps the technology was much better at recognising male white faces than it was at recognising female and black minority ethnic faces. I'm sure there will be something said about that in due course. And in fact, the court concluded in Bridges that there was not the evidence to support that assertion. But it is something that one has to think about when you are looking at the technology that is being used. Perhaps it would be said that the longer that this technology is used and the more that it develops, the less that risk is going to become, but it's something that one has to look at. So does green light mean go? No. It's only amber. You need to proceed with real caution.
Facewatch is a secure cloud-based platform. We hold and we store images of subjects of interest to you, low-level criminals. We're the data centre. That's our business, our core model. We use facial recognition. We don't write the algorithms. We use other parties' algorithms. So we're able to go into the market and source the highest quality algorithms there are out there. And I'm going to show you the ones that we use, the quality of those. It's all about preventing and deterring crime. We have no crime reporting facility anymore. We gave up on it as a bad job, as a bad exercise. Our whole business proposition is about deterring criminals from coming into your premises, and we've got some fantastic case studies that I can share with you. It's the only shared national facial recognition watch list. That doesn't mean you can share faces nationally. It means you have the principle of having a national watch list. There's a proportionality, there's thematic sharing of data, and Dave will go into that. And the big thing that retailers and businesses like is that we act as their data controller. So once they've followed our rules of compliance that's in the information sharing agreement and in their contract that gets presented to somebody every time they upload an image, we become responsible for their data. So why is there demand for this business? And there is a significant demand for it. We launched it about 14 months ago, started doing live trials, and we've spoke to the vast majority of retail businesses in the UK, most of the hotel chains. We recently did a trial in the prison services. We're starting talking to football clubs now. There's lots of different applications for this. But the biggest issue is retail crime. I understand retail, spent 30 years in it, so I understand the challenges of retail. And if you look at some of these numbers, they're outrageous. Only 7% of crime, shop theft, is reported. And that value is £2 billion. So it could be £20 billion circa of shop theft. There's £1.3 billion reported stolen by their own staff. It's unbelievable. The size of retail crime is unbelievable. It's described as an epidemic now. You don't speak to a retailer and say, do you lose stuff? The first question is, how much do you lose? And then they'll do their return on investment as to whether Facewatch is a solution for them. Shrinkage is what gets lost out your warehouse, damaged products, theft, and internal and external theft. It's about £5.5 billion reported shrinkage. Could be nearer, the estimates it's nearer £30 billion. But if you're a big box food retailer, do you know what operating margin Sainsbury's and Morrison's, Tesco's work on? About 3%. Technically that says I probably need, if I didn't have any shrinkage, I only need half the stores to make the same amount of money. That's the size of losses in retail. We've just run some really successful trials that have gone on to rolling out the programme for a medium-sized convenience store. One lost £60,000 a year, one lost £45,000 a year. It's nearly £1,000 a week. It's massive. It's a massive issue. 41,000 reported violent incidents against staff, 128,000 employees. That means you've got a 1 in 3 chance of being violently abused if you work in retail. 160,000 reported incidents of verbal abuse, someone threatening you, you know. Pretty significant. This is the sectors and the areas where it's growing in crime. So it's getting a lot more organised now. Gang crime's up 20%. Cyber crime, which is fraud, a lot of online trading now, nearly 19%. Customer theft, nearly 9%. A 9% growth in customer theft year on year. Can you imagine where it's going to get to if we don't do something about it, if we don't offer a solution? And supplier and warehouse crime, up nearly 5%. And that's why people are starting asking for access control. I want to control access of people going into my warehouse, so it's almost permissible. The bottom line is, as I say to everybody in my Yorkshire dulcet tones, it's not a pretty picture. You know, I've looked at retail crime go up on a reported number by 40 million a year for the last 6 years. Some as a retail and some as a CEO of Facewatch. That number's nearer £400 million. You know, there's about 7% is getting reported. So 93% is not getting reported. So the numbers are significantly different from what you read in the public domain. If you read the government information, I think it says retail crime's at 740 million quid. Well, there's one retailer in the UK that loses more than 740 million pounds. So that number can't be right. The biggest challenge is there's 21,300 less police officers since 2010, and there's 35% new types of crime that didn't exist in 2010. The only person who wins out of this, of course, is the low-level thief, because we've printed in the public domain. I normally pull the pictures up, but I took some slides out for this deck about the statements from the police. I don't blame the police. The police just don't have enough resource, so they have to say we're not coming out for less than £200. We're not coming out for less than £100. The criminal reads this. He knows that the businesses are apathetic towards reporting crime, so you're almost educating the criminal. If you just sneak 100 quid, you'll probably get away with it. You'll probably be okay. Nobody will report you. Eventually, they'll get caught. So the model going forward is, how do you stop those people coming into your site? What do you do to deter them? How do you share the intelligence that you could get caught? Because the biggest fear for a low-level criminal, you're not talking about serious criminals, you're talking about low-level guys who nick meat and sell it to the local pub or nick meat to order, is they just don't want to get caught. So why would I go somewhere where they use facial recognition when I can go to a business that don't use facial recognition? So I'm not really doing the police's job. I'm doing a job for the subscriber to Facewatch, which is likely in early days to disperse that traffic to another retailer. Eventually, if you get enough penetration, it'll eventually deter the crime. We originally started off in retail environments, but obviously we've seen organisations business managers known as from lots of different organisations. So we've migrated into virtually all these sectors. We're not in estate management yet, but we're talking to an estate management company. So independent stores, arenas, football clubs, bars, restaurants, hotels, petrol forecourts. You know, petrol, £35 million worth of fuel gets stolen every year, reported. They think that's about 100 million. And there's twice as much gets stolen from the store. Your average petrol forecourt, you've been in them, they've got eight pumps and a nice looking little convenience store. They lose about £6,000 to £11,000 on average just out of the shop a year. 68% of the driving population shop once a week in one of those stores. Incredible, the footfall and volume. What we've done is commoditised it. We use a standard HD camera. It's mounted at 10 to 15 degrees at a catchment line. Catchment line is usually the entrance, the doorway, where you want an alert, you want to immediately know who's coming in. It captures the image, it sends it to our technology, which sits on an Intel Edge box. It converts the image to an algorithm and sends the algorithm to the cloud. And so it's an algorithmic match to an algorithmic match, and in Facewatch it's 93%. That's the rate of the development in the last 2 years of facial recognition technology. The original threshold level was 70. It's now 93%. It'll then look for an algorithmic match, and in that watch list there's what they call partition files. If you look at the Facewatch cloud, it's broken into 3 sections. All data's all stored separately. It's all encrypted. It's all in the cloud at AWS Tier 3, so it's super secure. The first partition is the algorithm, is where we store the algorithms of subjects of interest, people who've been reported for crime. The second partition is where we've got the original thumbnail of the picture that matches the algorithm. And the third partition is if there's a gallery, if those people are frequently getting reported for crime. What it does, it goes up in the same way that Fiona explained about South Wales Police. If there's no match, the algorithmic data is immediately deleted automatically in less than a second. It just goes straight in the bin. So to dispel the myth that if you go into an environment that you're on facial recognition, your face will be recorded, it'll be stored, and you'll never be able to walk around again without getting alerted. If you're not a subject of interest, it doesn't make any difference. The algorithmic data is gone. What it does if there is a match it takes the edge box, it takes the image that's in the cloud, and then goes and captures the image that's just been captured of the person walking on the edge box, matches those images and sends them straight to a client's device. And it can send multiple alerts. So if you run a monitoring station, it can send it there. If you've got a security guard, if you're a store manager, you can send multiple alerts to a device, usually a mobile device or a tablet, but you can send it to a screen like that. And all that happens in less than 2 seconds. So I walk through the door, it'll do all that work, and within 2 seconds I'll get an alert pop up on my phone. And Dave will show you what appears on that phone, but you'll see an image of it. But very briefly, it probably won't have a name. Most thieves, you don't know the name of them, but it'll tell you a percentage accuracy score on there. So it'll be 99.56% accuracy score, and it'll tell you the code in why they've been reported. So letter T will be a thief. And what happens in retail, it'll have happened to you nearly every time you go in retail, especially in clothing retail, happens a lot, where you walk in the store and someone says, "Can I help you?" And you always say, "I'm just having a look." And then in the follow-up is, "I'll be right behind you if you need any help," which means two different things to do to two different people. If you're me, it thinks, well, he or she's very helpful. If you're a thief, it means you're going to be observed.
Good morning, everyone. So I'm Dave Sumner, Data Protection Officer for Facewatch, and I'm going to talk to you about the uses of facial recognition, and you can do it in a way that's legally compliant, or you can try and hide below the radar and not be. There was a case about a shopping centre in the north of England in the news yesterday that had run a trial some time ago, and the camera commissioner had expressed concern. You only had to read the details. They too hadn't published a privacy notice or any warnings, unlike South Wales Police, that facial recognition's in use. It's just one way a data protection officer, if you listen to them, would help you comply with the law and avoid the massive fines that exist to do with the Data Protection Act. So there is a lot to the Data Protection Act, but I'm just going to focus on the lawfulness side, because having a lawful basis for the processing is essential. Right, it gets a bit heavy here now, but I want to illustrate two different use cases. Anybody who's processing personal data has to have, under GDPR, an Article 6 legal basis. And I've popped up two there. It's either got to be necessary for a task that's in the public interest, preventing crimes in the public interest, or it's got to be necessary for the purpose of a legitimate interest that you are pursuing. If you ever rely on that lawful basis, you have to do a balancing act, a balance between the rights of the data subjects, each and every one that you're processing, and your own legitimate interests. And if they don't outweigh those of the data subjects, you haven't got it. But really important, if you do rely on this, to do a legitimate interest assessment, as it's called. So the stores that are processing faces, either in their back office or uploading them onto a computer, onto a Facewatch system, or their own bespoke internal system, everyone's got to have this legal basis. You've got to be able to demonstrate that it's necessary. What all the processing that you are doing is necessary. The attitude of the regulators and technology is, just because you can do it, doesn't mean you're allowed to do it. We can use personal data to achieve our legitimate interests, provided it is necessary to do so. And I've just described an example in the retail environment where that security guard, it costs a lot of money. They can only have a limited effect as a capable guardian. The next lawful basis is a tricky one. Now, Article 9 GDPR relates to processing sensitive personal data. Now, that's biometric data is sensitive personal data. So any facial recognition system converts some personal data, a photo, into a lot of ones and zeros that makes them uniquely recognizable. That part of the processing is sensitive personal data, biometric processing, and requires a second legal basis to do it. Now, this will be important for you, either advising your own clients about the use of AFR, or if you've got your own AFR system, about whether indeed it is possible you can meet this test, the so-called substantial public interest test. So you can only do biometric processing, facial recognition, if to do so is in the substantial public interest. Now that was a new term on me when it first came out, so we've got to look to see if it is defined. But again, the law tells us you can only rely on this if the processing is proportionate to what you're doing. It's not a sledgehammer to crack a nut. You've got to protect that data and at all times safeguard the rights of the data subject. So, for those of us in law, we'll be both not surprised and frustrated by this definition of the substantial public interest, because this is what the law says. You can read it in your own time, but this condition is met, so that's the substantial public interest condition, if it's necessary to prevent an unlawful act, if it can't be carried out with the consent of the data subject, and it's necessary for reasons of substantial public interest. But forgive me, but to me that says the processing is in the substantial public interest if it's in the substantial public interest. It's there, it goes round and round. How on earth do you solve it? Well, as we've seen in law, test cases, common law, they gradually define the law and tell us what it means. So until we have that point satisfactorily addressed in the courts, because that's all we've got to take a general approach from what we know already to define it. And I sat with the Information Commissioner's Office and the legislators who are writing the current Data Protection Act when it was in draft form to wrestle with this. Because, you know, when we work in law, we all understand the law, society and technology works quicker than the law. But very often laws can keep up because they're very well written, or they might not be, and there's grey areas. That's law all over, full stop, not just the Data Protection Act. So this is what our takeaway was, that we can meet the substantial public interest, so this is the biometric side of facial recognition, if you're taking a multi-site approach, and that's really important. If you're operating your own facial recognition system without consent, so people haven't, it's not access control, people haven't consented, how do you meet the substantial public interest? Whose interest are you serving other than your own? And I would argue, unless you're a very big retailer, Tesco for instance, with sites everywhere, it would be extremely difficult to make a case that you are meeting the substantial public interest. You meet your own interest and nobody else's. So again, to meet this SPI test, it's necessary to provide alerts to business subscribers to prevent the acts. It can't be carried out with consent. And that's about all that we've got other than legal opinion. So we, as a data controller with a nationwide system, can serve more than just the subscriber. So if you're Morrison's in the high street and you've uploaded your thieves onto the database and it's a Facewatch system, well, when Better Buy, just down the road, who are also a subscriber, if the same thief then walks into Better Buy, who's stolen in Morrison's, Better Buy get the alert. You're serving more than just your own interest on a multi-site approach, and in so doing are meeting the substantial public interest rather than just the public interest. So if you're a Facewatch subscriber, you don't do any biometric processing. Facewatch do it all. But if you go to a store and buy your own system and just have your own watch list, I'd argue you cannot meet this test. And therefore, all the processing would be done illegally. Our processing meets the requirements of the Data Protection Act.